3 years, the Internet and Lawyer Advertising, Lawyer Marketing. I can tell you that we've got a terrific panel. I've enjoyed spending my time with them. My role as moderator is a simple one, is to get the hell out of the way. In line with that, I'm going to skip over any biographical information because you've got some rather complete biographical information in the pamphlet there. For the students in the room, I want to give a little bit of background here that commercial speech is protected under the First Amendment. The protection that it gets is less than other covered speech, though. The test there is something called the Central Hudson test, and it's an intermediate level of scrutiny. The protection does not apply if the speech is false or misleading. And then there's a question about the application of prior restraint doctrine to it. There's dicta from Brennan in the opinion that that doctrine does not apply. That's sort of a legal backdrop to what our speakers will be talking about. And let me tell you, give it to you in a bit of an overview. Micah Buchdahl is going to give us an overview of issues involved in lawyer marketing, lawyer advertising, and then an overview of the types of sites involved, which we'll use the PowerPoint for, and I think you'll find it terribly interesting. He'll then put the two together, and what are the primary issues in each one of those sites. We'll then move on from there to Paula Frederick, whom many of you know. She's the Deputy General Counsel of the State Bar of Georgia. And Paula is going to give us an example of what's referred to as a home state regulation. And that is the application of Georgia rules to Internet advertising. Georgia rules are not, Georgia does not have Internet-specific rules. It's variations on the model rules, and Paula will be talking about what it's like to try to apply those rules in this completely new and, for the most part, unanticipated setting, unanticipated for the drafters of the rules. And then finally, Diane Karpman is going to talk to us about assisting firms with compliance problems beyond the home state. Diane is involved in compliance work, as is Micah, and one thing that Diane does is assist in rollouts of advertising campaigns, and in the process of doing that, setting them up so that they're in compliance with the regulations in other states, and especially something that you'll refer to as the sticky states. And so Diane Karpman is our last speaker, and with that I'll turn it over to Micah Buchdahl.
Good afternoon. I'm going to take about 20 minutes to talk about some slides that I usually talk about for about 4 hours, so I'm going to be very quick. And really the purpose of my opening for 20 minutes is to really give you a really fast overview of some of the issues that come about. Jack mentioned Central Hudson. I show you the website of Van Osteen, which comes from Van Osteen was along with Bates and Osteen v. Arizona, the person that I call the grandfather of lawyer marketing. Lawyer marketing as a whole has only existed for 30 years. If you basically take the 30 years of lawyer marketing, which is, again, still relatively new to people, and you combine the internet and technology, it makes things very difficult for some to sort of keep up. Just because you're lawyers doesn't mean that you know how to market. I just show you this site, not because there are any ethical issues regarding it, but because they thought it was a good idea to call their website BS Legal Help. It's always a reminder that some genius there thought like, oh well, our names are Bernard and Kaczynski, let's call ourselves BS Legal Help. That's usually not the kind of marketing you want to do, but there are a lot of people like this, or a lot of firms like this, that still have trouble sort of grasping the importance of advertising and marketing properly. One of the people that I always point to as one of the premier users of technology among lawyers in this country is Greg Siskin, who has basically taken the internet from the mid-90s and built one of the most successful immigration law practices in the country, if not in the world, using websites and using the internet. This is the site as it looked in 1997. In 1997, I was doing lawyer marketing panels with Greg, and he would sit there talking about this site, and this site was state-of-the-art, cutting-edge in 1997. I mean, people were blown away by it. And if you go to that site today, he has continued to use technology, as I always say, for good as opposed to evil, in regard to the way that he markets and sort of shows off his practice. One of the things that that's key to Greg's success is that he's done it in a way that most people would find to be very palatable and very professional. There aren't people that I have ever heard talk about Greg in negative terms in regard to his sort of entrepreneurial nature, as opposed to many of the other law firms that, often plaintiffs firms that are doing things that are a little bit outside the box. When I talk about internet ethics as it relates to advertising, what we're talking about here today mostly relates to the advertising restrictions, but this is one of my oldest slides in my deck that hasn't changed much in 10 years. What are some of the aspects, the underlying aspects that you have to concern yourself with from an advertising standpoint in terms of not just ethics compliance in terms of advertising, but some of these other concerns. The concerns of developing a website in which you make it too easy to create an unwanted attorney-client relationship. That you make it too easy for someone to give you all the data and assume that you are now representing them. There are attorneys that have had trouble with this. The issue of competence really comes up when it comes to, we'll talk a little bit about blogs and websites, is whether or not you are now promoting yourself on the web in regard to an area that you actually know how to practice. I remember sitting with a general practitioner a number of years ago where his practice area list started with antitrust and ended with zoning and had every conceivable practice area in between. Was he competent to actually practice in those areas? Probably not. Confidentiality and conflicts both come into play. And again, the concept of using the internet via email, via referral sites, via your website, in which you have not had the opportunity to do a conflict check, or in some occasions being conflicted out of matters due to the way that you use the internet for marketing purposes. One of the examples that I often give people that I dealt with a couple of years ago, a large employment law firm, very big national firm, somebody gets fired in their community, they basically go online, they look for they want a big labor law firm to represent them, they don't know the difference between a plaintiff's firm or defense firm, they just wanted a big labor law firm, they go onto the website, they find a guy, they send him an email, they attach documents, they tell the story. Well, sure enough, in that community, the big corporation that fired him is also the big corporation that uses this law firm. And basically, in this particular instance, the law firm ended up having to be conflicted out because of the fact that they now had they now have the story, they now had all this information. Unauthorized practice of law, I'm going to talk about a little bit in regard to competition that lawyers have with non-lawyers that are practicing law on the internet, and the issues that people have to face in that regard. You're sitting there trying to comply with these ethics rules, the rules that the panel's going to talk about, yet there are people that are not members of the bar, they're not lawyers, and in many cases they're not scared of us or the bar. And so they're setting up shop, they're dispensing legal advice, they're not lawyers, but you're competing against them. Multi-state jurisdiction, again, another area that the web has basically made it very easy for us to, has made it very easy for us to market outside of our home state and our home territory and the places that we practice. It's very easy to basically practice throughout the world. Now, I always say, as I said to Jack at lunch, the fact is, like, people will say to me, I'm marketing on the World Wide Web, and I'd say, like, well, you do not need to comply with the rules of the world, okay? Like, you don't have to go find every rule in the world and make sure you comply with them. But I think, Diane, you were at a program that I did this summer in New York, where the disciplinary counsel for the Connecticut...
I have the article on that.
Okay, for the Connecticut bar, basically suggested to the audience that if he could access your website in Connecticut, you were practicing law in Connecticut or you were under their jurisdiction. things like that.
They had to submit it quarterly.
Yeah, and it's just ridiculous, but it's in effect. And then fee sharing referrals, the way that you actually generate business off the web. One of the things that I always point out to most law firms, excuse me, is the importance of the disclaimer. And you will find in many states, they will make it clear to you. Make sure the legal disclaimer is on there. Make sure it complies. Make sure it has the right information. In this case, if you look up here, I just picked Jones Day. They start off with the attorney advertising. The prior results do not guarantee a similar outcome. That's language that's specific in many cases to New York. Trying to comply with the New York rules. At the bottom, they have Texas rules of professional conduct. They're trying to comply with the Texas rules. And in the middle is a very interesting couple of sentences that has become more and more prevalent with people, is attorney experience. And that's a fight that many lawyers are having with their prior law firms. Is your lawyer experience, does it belong to the firm or does it belong to the attorney? And if I represent you and I'm with the firm and then I leave the firm, is that still a representative client of the law firm? It's been an interesting area, and Jones Day is one of the first to see that I've seen add that kind of language to the disclaimer page. Morrison & Cohen, I'm showing you this site because, again, this is another timely example. This is a law firm that Donald Trump recently sued because he wanted them to take his name off their website. And he got mad. He hates these guys. He sued them. He said, stop saying that you work for me. I don't want to be a representative client. Now, in a number of states, you would not be allowed to list Donald Trump there without his permission. And even in states where you do not have to seek that permission, 99% of lawyers will sit there and make sure that it's okay with their client. And certainly if the client says, I would not like to be listed, don't list me, you'll take them off. But in this case, in Morrison & Cohen, and I just grabbed the screen capture the other day, they keep Trump on there, despite the fact that he sued them for putting his name on their site. I'm sure Diane's familiar with Top Gun DUI, and one of the reasons I keep Miles Berman in my program is that his slide's been in my program since 1997. And it's one of the first law firm websites that I ever saw. It's a lot more proactive and interactive and different today. But the bottom line is that Miles Berman has built a tremendously successful business off of the internet, just like Greg has. Now, there are going to be some people, just like there are very few people that sit there and look at Greg's immigration practice and find it somewhat distasteful. There are many people that look at Miles in various markets and sit there and think, there are things there that are outrageous. There's the link to the cop hideouts. And my favorite page is really the page that lists his partial list of successful DUI cases, in which you had a blood alcohol level of 0.21, dismissed. Okay? And if I'm ever in California and I was drunk and I got picked up, and I would never do that, but if I did, I can tell you the first person I would likely call is Miles Berman, Top Gun DUI.
Across the street from my office.
Yeah. But you also find like the argument that's made in terms of listing results is that, say I went to Miles and he represented me and I lost or I was convicted, and I'd say, well, my blood alcohol level was 0.19. You got off people that were 0.21. You misrepresented yourself, you misled me, but the concept of listing results is often very critical, is often very controversial in a number of states. And people throughout the morning refer to the pit bull and the famous pit bull case. And I love Paper Chandler. These guys are great. I interacted with them a number of times. I did an ABA program with Mark Chandler. And this is one of the great rarities nationally. And that is the law firm that receives the letter from the bar saying that you were in violation of rules X, Y, and Z. And they go, and so they continue to market and they disagree with it. And this case went on for years. Both the State Bar and Paper Chandler spent a lot of money fighting over that cartoon dog. That's what the fight was over. Whether or not the cartoon dog is deceptive and misleading. Okay, and they lost. And they had to go to attorney advertising school, which is like the drunk driving school for attorney advertising in Florida, and pay them $250. But if you go to Paper Chandler today, after their years of fighting, what they have now is this horrific robot that comes flying out. And you hear clanging and noise from this robot. And so the question I asked the disciplinary counsel, who I've become very good friends with in Florida, I said, I guess we all know that robots are not deceptive and misleading by nature. And then she replied to me that I don't watch Star Trek. So, you know, it's just interesting the way, the arguments and discussions over, whether a dog or a robot is allowed or disallowed. And it really lends itself to the subjective nature of a lot of the things that exist on a state-by-state basis. Here's a photo gallery from a law firm in Philadelphia. And they recently issued an ethics opinion in Philly, and it doesn't say that it's this one, but I personally believe it's this site. And it's whether or not it's appropriate to have these photos on there, and are they really a form of client testimonials? Are you trying to suggest that these are clients, that I represent Arnold Schwarzenegger, that I represent Bon Jovi? And if you go on down the page, Bill Cosby's there, all kinds of people are there. And so the question is whether or not you can have these photos on there, and whether it's misleading to have these photos on there. They're not clients of the firm, and to me, putting up personal photo gallery that is not the disclaimer that I would be looking for. But this site's been up for a while, and this stirred up some controversy in Pennsylvania. As did this site. This is helpyourbaby.com. I looked for it again the other day. It's gone now. But basically, this site deals with how did your baby get cerebral palsy. And it's got the little doctor there in the white coat. It's very educational looking. This is a law firm website. Okay, does it say that it's a law firm website? No. Does it identify the law firm? No. Does it identify in any way what their true purpose is? What is the true purpose? It's obviously to look for clients. And so there are still people out there that are still creating these sites that in no way comply, and in many ways go completely against the reason that we have our rules of professionalism in place. This is E. Eric Girard in Louisiana, and I point out Louisiana specifically because Louisiana is on the verge of basically implementing some of the strictest rules in the country. And if they, as of December 1st, if they implement those rules, a lot of the things that guys like E. Eric Girard will do or have done will have to change. The reason I like to use Eric here is because, again, he's another example of a young attorney. He came right out of law school and basically built a very successful personal injury practice right out of the gate by using marketing. And this guy's just a marketer, okay? The E, Eric Girard, the E stands for nothing. He added it on there because he thought it sounded good for marketing purposes. In some states, you might question the URL that you probably can't say there, the E guarantee. The guarantee. Guarantee is not necessarily the word that I would likely use in a number of states in terms of my URL. What are you guaranteeing? Obviously, we're never guaranteeing success.
By the way, I'm sorry, the Louisiana Supreme Court, having been sued, has delayed implementation of their rules till April. I just got that over the website this morning.
And a lot of times you read these rules, like the rules in New York and into New Jersey, and as soon as we read them, we know that they're never going to pass muster and they're never going to fly, but people are still trying to put them into place. The blog is a very interesting area, and the question regarding a blog is a blog different from a website? My friend Mike Downey and I, when we talk about it, he'll say, a blog is a website is advertising, advertising needs to comply with our advertising rules. There are other people out there that try to suggest that a blog is more editorial, it's more journalism, it's more information, and the question is it or is it not? And the problem really is, who would ever decide which blogs are informational versus advertising? To date, these blogs should comply with the ethics rules for websites, but I would guess that the vast majority of them do not. Okay, now this is a very standard one, the Delaware Employment Law blog. And law firms are trying to get creative. This is one of my favorite ones. This is by an associate at Ford and Harrison. It's called That's What She Said. And it actually takes episodes of The Office each week and actually plays out the real-life employment law implications and costs involved with every episode. Lawyers are trying to become a little bit more creative in the way that they market. This is one of the most creative and successful ways. I really enjoy this site. And then law firms have had to deal with other blogs like Above the Law, which is literally like the lawyer version of TMZ. It's like a tabloid that basically dishes dirt on what's going on at law firms. And between that and the Skadden Insider, which is very similar, it's a tabloid and Skadden, it basically shows the power of the internet that law firms can't really control a lot of that information that's disseminated that relates to them. You can't control your image online the way that you could control your image previously. And I've shown you the platform just to show that this isn't something just about practice. This affects in-house lawyers as well. This is the Cisco site. The Cisco site previously had an attorney there that was behind the patent troll blog. And until it was uncovered that it was a Cisco lawyer basically out there looking for, trying to identify patent trolls. It became a very ugly battle. The guy who created the site at Cisco is no longer there. He's actually practicing in California, right? And then and Cisco had to implement a new employee blogging policy, but they actually had to implement it because of the work of an IT lawyer at Cisco. That's what kind of created the need for the revised update on employee blogging. YouTube, another great area for potentially marketing. If you go on YouTube and you look for lawyers, you can find Q&As. You can find the actual TV commercials. There's some great, blow-up commercials. If you want to see a bunch of things blowing up that are lawyer commercials. There are seminars. There's all kinds of information on there. But again, law firms have to be careful of what they put on there, and you can often lose control of what you're putting on there. Now, what they did, what Cohen and Grigsby in Pittsburgh did, it's not necessarily an ethics violation, but they actually thought it would be cool to put some of their seminar dealing with how to avoid the green card rules and how to avoid hiring Americans. Was sort of the seminar. It goes up on YouTube. A lot of people don't like the idea of lawyers teaching people how to avoid hiring Americans. And so if you go onto YouTube now and you look for Cohen and Grigsby, or you look for that information, what you'll see is Lou Dobbs bashing them and Glenn Beck bashing them. You'll see NBC and CBS. You'll see lots of clips of people bashing this law firm. That seminar's gone, but the remnants of what they did is not gone. It will not be forgotten. The question again, YouTube. When you put something up there, when you put a clip up there, are you going and filing that in your state in terms of attorney advertising? My guess is not likely. You get a lot of YouTube information, but there are a lot of YouTube's clips up there. Is that advertising? Sure it is. We the people, again, that's non-lawyers trying to practice law, as is Lexington Law. These are entities that have basically sort of put themselves out there, and we are often competing against them. They are not law firms. They're not supposed to be practicing law, but we're competing against them. We're competing against them online. And it's a lot harder to discipline people that aren't lawyers and that aren't members of the bar. You can't discipline people that aren't part of your organization. You have to send the state after them. And then the concept of the virtual law office, which you read a lot about now. This is the Virtual Law Partners, and it's a group of lawyers that are mostly doing corporate law throughout the country. They're based out of their homes in various parts of the nation. And the question is, again, where are you based? Okay, where are you practicing law? And so, if you look at the home page, the answer is nowhere and everywhere. Okay, so in some states, I would suggest that it wouldn't be unusual if I were an attorney in a certain state and I lost a piece of business to the Virtual Law Partners, that I would basically go and suggest that they were competing for business against me and not following the rules in their state. These are issues that come up in regards to the Virtual Law Partners. The concept of law firm referral networks. Legal Match is one of the popular uses of online pay-for-play advertising. Google, again, other concepts of pay-for-play advertising. What are advertisements? Down the right, sponsored links, advertisement. Up at the top, advertisement. What about the rest of those listings? The rest of those listings are organic searches. However, a lot of very entrepreneurial attorneys have gone and hired people who spend their days getting themselves placed with the right language there. Okay, are those advertisements or not? They're organic searches in the world of Google. The others are ads. Are you complying with the rules? And one of the areas that people are spending more and more time in, depending on your practice area, are areas like Craigslist. I know a lot of attorneys that derive a significant amount of business off of Craigslist. So here I go to Philly, I do a legal services search, and you see a bunch of law firms up here offering legal services on Craigslist. Again, is that lawyer advertising? Of course that is. I know people that have hired people who spend their days, every day, they relist their attorney so they come up near the top on legal services. Craigslist. How many times, Jack, if you sat there in your committee and sat there and said, well, what are we going to do about Craigslist? None, right?
We have in Georgia, yes.
Oh, that's very good.
I'll tell you about it.
Okay. The emails that you receive. Here's an email, a spam email that I received as a consumer basically soliciting business. Here's another one that I received as an attorney offering me clients. Both of these are inappropriate in a variety of ways. The way that you receive this information, and I always have to remind lawyers that just because somebody calls you and has a case that they send your way doesn't mean that it was done through a legitimate fashion, even if it's through some overarching legal marketing business. Who can I sue is another new entity. Okay, I've seen their billboards, I've seen their TV commercials. Again, another attempt to basically marry lawyers and clients through the web, through something like who can I sue. And then I'm going to go into real quickly like the concept of divorce. Okay, everybody's talking about divorce. Divorce is a great example of a consumer-driven practice. You know, if everybody in here who's married, you raise your hand. Raise your hand if you're married. Okay, half of us will need a divorce lawyer at some point in time. Okay, it's not as good as death and taxes, but it's 50% of the way there. Okay, so here's a billboard that went up in Chicago, I guess about a year and a half, 2 years ago now, and it came down very quickly. But this billboard it was on the Today Show, it was in USA Today, it was everywhere. Does this billboard, life's short, get a divorce, does this violate the ethics rules in Illinois? No, it does not. What does it violate? Taste. Okay, and so what happens is people remind folks that these rules are not, they're subjective. If you find this billboard and this marketing campaign offensive, then don't use them. But they don't violate the rules, even though there was an uproar and it came down the next day. Now, the thing that I found extremely fascinating is that the attorney on here, these pictures, I don't know about the guy, but that's the actual lawyer there. Okay? That is the guy. Okay? That's Corey Fettman, the lawyer of love. And if you go to Playboy.com, which I have to do for professional purposes for programs like this, you will find her Q&A, her dispensing of legal advice. Again, if you find it offensive, you won't use her. If you find it clever, you might. And you can borrow my password. I had to really make sure that I knew everything about her. So there is a pictorial as well. But you have to pay for that. Divorce deli, again, another area where a law firm in Florida has created the divorce deli, making the practice of divorce law as easy as $249 without children, $299 with. And the concept of mediation in ADR is another area which is very interesting as it relates to the advertising rules, because a lot of mediators are not necessarily lawyers. If you're not a lawyer, you're not practicing law, then you don't need to comply with these rules. This is divorce done right. There are a bunch of lawyers, they're not practicing law. They have their disclaimer, they sort of have a little shield there between sending out the legal work and keeping it in-house. But the concept of mediators, lawyer mediators, often having to compete against non-lawyers creates some difficulty. The evolution of ratings and referrals. Chambers and super lawyers are two examples. There was a time when the only directory was Martindale. Martindale is struggling now to keep up with the thousands of lawyer ratings and referrals, and the concept of when you receive an award by one of these entities, you know, is it credible, is it legitimate, how can you market it? Avo is another site, again, a lawyer site where some lawyers in Washington State sued to try to get Avo shut down. They didn't like the fact that information about them was displayed to potential consumers and customers. There's a ranking to Avo. There's a concept to the way you're displayed, and you see here I have a no concern rating. That's my rating. But if I had a stop sign up there from some disciplinary actions, I probably wouldn't be too happy about it, and there would be nothing I could do about controlling it. JD Supra, another site that allows lawyers to market themselves. And then getting into one of the other hot areas of the last year or two are social and business networking sites. There's my Facebook profile. Just like with my Playboy subscription, my wife wants to know, what are you doing trolling on Facebook? Okay, and I'm always like, it's a part of my presentation. Okay, and so, and then you get to LinkedIn, which I personally find to be one of the most viable sources of generating business. The concept of LinkedIn is the question for many states is whether or not a LinkedIn profile and what you have on there is lawyer advertising. I could talk about that for an hour. It's a very interesting subject to debate. But if you go onto LinkedIn and you look on there, you will see attorneys from WilmerHale, and you'll see attorneys from Skadden, and you'll see a lot of attorneys that are out there with their profiles marketing their information. Second Life, again, another area, not so much, where I see a lot of people use Craigslist and a lot of people use LinkedIn. Second Life is cool and it's cute, but it's not an area that a lot of people have used really effectively this far.
But you can be a pit bull. You
can be a pit bull on Second Life. in your second life. And then I'm going to end with my last slide is just, just when you start to try to figure out how the rules are changing and how technology is changing, you have people out there selling text messaging of lawyer advertising through places like Text My City. And so, again, the concept of text messaging, sending out ads through your cell phone from lawyers is sort of what's down the pike. And that's a real quick overview of some of the areas that we concern ourselves with on a daily basis.
Thank you, Micah. That was terrific. Just like you tell from the pictures and the text, the pit bull lawyers actually were pit bulls. I don't know whether you noticed it or not, but one of the early screens at the top of the screen, it said fraud monitoring is on. I didn't know computers could monitor lawyer ads for fraud, but that's terrific. And if you could add false and misleading to that, just have the computer do it, then our next speaker's job would be much easier. Paula Frederick is the Deputy General Counsel, and these kind of problems come her way.
They do. We are the office that is supposed to interpret and enforce the rules of professional conduct and then prosecute lawyers who violate those rules. And so, as both speakers have already said, none of the rules on lawyer advertising were really created with the internet in mind. Certainly not with the extent of lawyer advertising and lawyer presence on the internet that we've seen in the last 10 or 20 years. Many states are trying to deal with this through creating rules that do deal specifically with internet and advertising. Georgia is not among them. We have a set of rules that is the same set of rules we've had since probably the late 70s, early 80s, right after the Bates decision that said that you can't outright ban lawyer advertising. We've amended them to comply with Supreme Court cases that have changed the rules on advertising, most of the time liberalizing the rules on advertising, but by and large they are the same as they were 25, 30 years ago, before all of this sort of stuff was even thought about. So, Part 7 of the Georgia Bar Rules prohibits lawyers from using advertisements that are false, deceptive, or misleading. And there's a little bit of a laundry list of things that we consider to be false, deceptive, or misleading in Rule 7.1. Other than that laundry list, it's in the eye of the beholder. What might be false or misleading to you might be something that a regular old member of the public thinks is routine. I mean, they all know that Robert Vaughn doesn't work at the law firm that he's advertising for, so why are lawyers so upset about people using actors in their lawyer ads? Is that misleading? Depends on who you talk to. In Georgia, though, we have tried our best to sort of move with the times and figure out ways that the rules that we've got can be used to regulate what is going on with lawyer advertising. And we're considered, I think, a liberal state in this area. We're not generally considered a liberal state, certainly with these rules or any other for that matter. But my office, the Office of the General Counsel there at the bar, in charge of enforcing the rules of professional conduct, really has taken what I think most people consider a fairly lenient approach to lawyer ads. For instance, we require that somebody file a grievance, or we have in the past required that somebody file a grievance before we will look at a lawyer ad to determine whether there's a violation of the rules or not. So we need to hear from somebody. Our process generally requires that we get a grievance from somebody before we conduct an investigation. And we've used that with lawyer ads even where I drive to work and hear an ad that violates the rules. I don't go into the office and start investigating and prosecute that person. If we don't get a complaint about it, in the past we haven't done anything. Now that has changed recently, and I'll tell you about that in a minute. But the other thing is that we really have tried to look at the Central Hudson test that Jack talked about initially, and how the public is being harmed by whatever it is that is being done, as opposed to whether you can take what's here and stick it into some kind of violation of a rule. So that there might be a technical violation. For instance, the slides that Micah just showed. People who have as their website, what was your DUI guy's name? DUI?
Miles Target.
Yeah. But what was his website?
TopGunDUI.
TopGunDUI.com. That's the guy's website. That's not his law firm name. That's not his name. So we're now practicing law under more than one name, something that the rules of professional conduct prohibit in Georgia. I think if we were really wanting to take sort of a hard-edged approach to this, we could say, you're violating the rules. You know, you're not Top Gun DUI attorney or whatever. You're whatever your name is. And so your website can only be called that. You know, the name of the site can only be consistent with your firm name. I think that if we wanted to take a position like that, that we could find some justification for it in the rules. Unfortunately or fortunately, I'm not sure which, we've got better things to do with our time in Georgia than sort of find things like that to pick on folks about. And so what we do when we see violations of the rules that don't appear to be harming anybody, we haven't gotten a complaint about them, or even if we get a complaint about something that seems to be a technical violation, we send a warning letter to the lawyer. We write the lawyer a letter and say, it's come to our attention that you've got this website and you said something on here that we consider to be misleading, or that could be considered to be misleading. Fix it. And most of the time, the lawyer voluntarily complies and does what we have asked him or her to do. It's interesting because this internet stuff is much easier to fix informally than a lot of forms of advertising that have come before it. For instance, when we, on the few occasions where we've had people complain about lawyers' advertisements in the Yellow Pages, you can tell a lawyer, your Yellow Pages ad violates the rules. The Yellow Pages people aren't going to reissue all bazillion volumes of the Yellow Pages when this lawyer has fixed the ad. It's going to have to wait till next year's issuance of the Yellow Pages for anybody to take care of it. So the immediacy of the internet, I think, in a way, makes it easier for people to fix the problems and go on with their lives without it becoming something that you know, sits around for a year or two before there's a replacement version of whatever it is that is issued. Now, in Georgia, we've been sort of rocking and rolling along with this, as I said, by very informally tackling these issues as they have come up. For us, the larger issue, much larger issue than print ads has been soliciting. And so the cases that you see in Georgia that deal with these advertising rules arise out of problems with lawyers trying to solicit business in person or using third parties to solicit business for themselves. We were sued over our rules in the late 90s in a case that was the result of a lawyer using runners at accident scenes to get business. The case went all the way up to the 11th Circuit, and the 11th Circuit upheld the constitutionality of the rules that we use in Georgia. So, you know, that's as close as we're going to get without going to the U.S. Supreme Court, and that is one reason that we've been reluctant to change the rules that we do use here. But there continues to be concern among Georgia lawyers about advertising. From what I've seen, I've been at the bar now 20 years. 20 years this summer. And it is true that the people most concerned about lawyer advertising are not members of the public, but are other lawyers. The complaints that we get about lawyer advertising come from lawyers. They do not come from members of the public. And truly, in 20 years of, 3,000 grievances a year, probably, I could count on at least these two hands, if not this one hand, the number of complaints that we have had from actual people, if you don't mind my using that term to exclude lawyers, but from real folks out there.
There's only two types of individuals. There's clients and there's lawyers.
Clients and lawyers. But we rarely get complaints about this stuff from anyone except for lawyers. And most of the complaints that we get stem from soliciting business from somebody who turns out to be somebody else's client. And sometimes the targeted mailings will have exaggerated claims in them, and we write a letter, and that usually does get fixed. But there is this feeling among the members of the bar that perhaps the enforcement that my office does of lawyer advertising problems needs to be more aggressive, that maybe we're too laid back about it, and that maybe we should go out and sort of affirmatively look for violations of the rules instead of waiting for them to come to us and prosecute these cases. So I think it was 2 years ago, the then bar president created a lawyer advertising task force to take on this issue and put on it advertisers, non-advertisers, some of the folks who are rabidly anti-advertising, and some of the folks who are some of the biggest advertisers in the state. So sort of a motley crew, which I think is good when you're talking about possibly changing the rules and creating new rules for something like this. So the point was, take a look at everything that we're doing, take a look at what we've got, decide if it's working okay, decide if it needs to be changed, and then maybe create a different mechanism for these advertisements and this soliciting conduct to come to the attention of the General Counsel's office at the bar. The solution that they proposed that's still in effect now is what Jack has called a neighborhood watch kind of a solution. Instead of requiring that we not investigate, that we have a grievance before we can begin an investigation into possibly unethical conduct, anybody who has a concern about a lawyer ad that they've seen on TV, heard on the radio, read in the paper, seen on the internet, whatever, anybody can contact one of several designated lawyers around the state. Just call that person and say, I saw this ad, I think it violates the rules of professional conduct, please have the bar look into it. They don't have to file a grievance that has their name on it, that shows that they're the one who was concerned, and the bar doesn't have to have a grievance form in order to begin the investigation and to try to get the whole thing fixed. Frankly, the process was created so, I think, to make it easier for lawyers to kind of police each other with this kind of conduct. Because lots of folks find it distasteful. You know, you probably should think twice before you file a grievance against another member of the bar. They're going to get the grievance, it's going to have your name at the top. You know, it's not an easy thing to do. This new process allows potential rules violations to be reported to us anonymously, basically. We don't care where they came from. We will take a look at whatever it is. We have to ask the lawyer quite often to provide us with the information to do the investigation, which is another reason that I think enforcement is sort of difficult in these cases. For instance, when we first created this task force and publicized the possibility of letting the bar know about ads that you think aren't ethical, we literally got a call from a guy who says, well, there's a lawyer, I can't remember his name, and it was on late night TV, but I don't remember the channel, but there were all kinds of violations in the ad. And so, okay, well, thanks so much for letting us know about that. But now, with a little bit more information, you know, the name would be good, the channel would be good, the time of night would be good, something to help us sort of move along with this, we can actually contact the lawyer and require that that person send us a copy of whatever it is that's being broadcast, contact the station, the radio and television stations have been very, very cooperative with this project, and get the advertisement, take a look at it, and then work with the lawyer on trying to straighten out any potential problems with the ad. So that program has been up and running for a year or two now. It is not as busy as, frankly, we feared that it would be in the beginning. I think that there are a number of, we have some best customers out there who really are doing more than their share in trying to keep the advertisements clean. But, you know, it's one of those things that we continue to kind of struggle with. Among the things that have been problematic for us, Micah mentioned, as he was scrolling through ads here, you know, is this an advertisement? And quite often he said yes when I would have said, I'm not sure it is. You know, I don't know. I have a Facebook page. I'm a lawyer. It says so on my Facebook page. It's not out there for me to get business. I don't want business. I've got more than I can handle. So the fact that you are a lawyer who has a presence out there on the internet doesn't necessarily mean that you're advertising for business in a way that's any of the bar's business. And, you know, there's some funny ones out there on YouTube. We've got a Georgia lawyer who's got some ads on YouTube that look like they're about to turn into a porn video. And you're sitting there going, well, you know, what kind of client would find this interesting? But they don't, thankfully. On the other hand, I had to go search, Georgia lawyer, porn video, you know, all these things to find that. And so the concerns for somebody like me who's worried first about the public's protection and the public potentially being misled by something that's out there, have a little bit less sympathy when it's taking you 20 minutes to track down the thing that might mislead you. You know, it's hard to say that that's something that deserves the same level of scrutiny, the same rules to apply as, say, a letter that you're sending directly to an accident victim or something like that.
I'm just glad that I'm not the only one looking at porn for professional.
It happens all the time, the whole office. And in fact, I found on my computer, now this was brought to my attention by someone else in the office, but I felt it was my duty to take a look. And I try to pull up YouTube, and I get this big black screen that says I've attempted to access a site that's banned by my IS department, and I've been reported. So I don't know why some folks get it and some folks don't. Yeah.
I'll ask you a question. Our patent is primarily in tax law, and all these companies that advertise on 800 numbers, offering compromises with IRS and helping people with taxes, they're getting lists of them. They're soliciting people. They're ripping a lot of them off. About 30–40% of the people that come to my office have been ripped off of these things. They're not really subject to any regulation.
Are they lawyers? Who are they?
No, they're just
And here over here, what he's
qualified representatives with IRS.
He says that there are these 800 numbers or websites?
Well, they're just not different numbers advertised on TV. Like
Okay.
One of the big firms is J.K. Harris. There's about 20 or 30 of them that advertise on TV. They get tax lien indexes off the clerk's websites. They call people, solicit for help, which would be almost legal help with the IRS, and they rip them off.
Tax liens, do you get the gist of it at this point? It's non-lawyer telephone numbers or advertisements on television soliciting business from people who have problems with the IRS. They are not lawyers and they don't appear to be subject to any regulation. I think that is a particularly difficult area because you can probably be an accountant and help people with a tax matter too. But
it's worse than anything I've seen that's
in other areas of
in
law.
the Georgia bar or anything about what attorneys do in the first lead directive is far worse. And I'd say 3 out of 10 or 4 out of 10 people come to my office have already been ripped off by these things from anywhere from 3 to 5,000.
Let me interrupt for just a second. Thank you for the question, but if you don't mind, let's hold the questions until the panelists are finished. It's going to make the job of the student editors extremely difficult if we don't, and the court reporters as well. But we'll get to questions.
I am running out of time, but I want to give you sort of a laundry list of the sorts of things that we wrestle with and really haven't come to terms with. I think we approach these situations on a case-by-case basis, and we try to sort of maintain our sanity in figuring out how to deal with them. And I think that's the commercial speech test. You don't just get to say no because you wish it wasn't there. I mean, there needs to be a reason for saying that something is outside the bounds of the rules. And you have to remember that these rules, the rationale for allowing lawyer advertising in the first place is because it does serve a valuable function in educating the public about their legal rights, letting people know when they have a legal problem, and helping them find a lawyer. So it's not all just bad. But here are the kinds of things that are sort of hard for us to deal with. Websites do go all over the world. If you can access the website here in Georgia and the law firm or lawyer acts like he or she can handle a case for a person in Georgia, then we do, in the State Bar of Georgia, believe that we have jurisdiction over that person's conduct while they are either virtually in our state or representing a Georgia client. Now, we've never tried to prosecute somebody for what their ad said that got the Georgia client to hire them. We are more interested in whether the client was harmed by the relationship otherwise, not necessarily how they got there. So if you've got a website and you're in Spain and a Georgia person hires you and you screw the case up, we're going to think we've got jurisdiction over you for that part of it, and not necessarily just by virtue of your advertisement being beamed into our state. we've seen a lot of weird little problems. We have seen Craigslist issues. Lawyers and creative loafing in Craigslist are my two favorite. If you want to find some ads that violate the rules, Craigslist and creative loafing. A lot of folks seem to forget that they need to include in their advertisement their name, or the name of their firm, or the name of a lawyer. And that's our current cleanup on Craigslist, is there are a lot of ads that are listed there without any lawyer's name there. Let's see, we've had grievances filed by people on the other side of a case. It's very similar to the Donald Trump situation, where it's true that we represented this person, and actually it's the opposite of the Donald Trump situation. My client has given me permission to tell her story on the web. Great success story, I represented her, we had a great result, it was wonderful, and you should hire me as a result because I, by implication, can do similar sorts of things for you. In telling the client's story, the lawyer reveals things about the other side. And, they aren't privileged, I guess, because we learned them in the context of litigation. Nonetheless, they're things that this person doesn't want floating around out there on the World Wide Web. And so we've had adverse parties contact us to say, can't you make this lawyer take this stuff about me off his website? Of course, you get that call and you're like, yeah, he's not supposed to violate, you've got the right to confidentiality in all your dealings with your lawyer. Turns out it's not their lawyer, it's the opposing counsel. So that happens quite often, and there's not a whole lot you can do about it. Similarly, there's not a whole lot lawyers can do when somebody tells a lie about them on the internet. And it's interesting to me that because we regulate what lawyers say, lawyers believe that we can regulate what other people say as well. So we'll get calls from a lawyer who was offended that there's untruthful information about the lawyer out there. We get calls from people who say, I'm listed on this referral site, and I haven't given them permission to list me. What can I do about that? I don't know that there's anything you can do about that. The one that we're wrestling with now in Georgia as well, and I know I'm out of time, so I really am going to stop talking in a minute. We have decided that we're going to try to define what a lawyer referral service is for purposes of these rules. And I see Roy Sobelson nodding his head because he's on the Formal Advisory Opinion Board and they are going to take this on for us, I think. But I personally was sued after writing a Bar Journal column. I'm sued all the time. They're either mad because I'm prosecuting them or they're mad because I didn't prosecute or whatever. But I wrote a Bar Journal column that sort of illustrated this problem. And the example that I used was this website called IneedALawyer.com. And I'm a lawyer, I knew. I went on the web and typed in IneedALawyer.com before I used this as my example to be sure there was no such entity. And there wasn't, or at least it appeared to me that there wasn't. You went to one of those weird little blank pages. So I use it in my column. And then about a month later, we get sued by some guy in Canada who claims that he's reserved IneedALawyer.com for his proposed business. It was kind of Joe the Plumber-ish, He's got these billions of dollars in damages for this business that he hasn't even started, but he had reserved the name in Canada. So thankfully my lawyers were able to get that dismissed. But the point is, can these entities that say to you, lawyer, if you pay us money, anytime somebody types into our web engine, Georgia divorce lawyer, your name will come up first. They claim they are not lawyer referral services, they're marketing entities. What's the difference? And that just shows you my opinion. But anyway, we've asked the Formal Advisory Opinion Board to take a look at that for us and just tell us if they want us to treat those entities like lawyer referral services, which would mean they have to register with the bar, they have to pay a fee, they have to tell us what Georgia lawyers have subscribed to them, etc. The one last thing, and this is the last thing that I want to mention that Micah didn't mention, and that's the only reason for mentioning it, is these listservs where groups of lawyers gather to help each other. As opposed to, I honestly don't think they are advertising for business, but my favorite one is Solo Says, that's through the ADA's General Practice Division. Groups of solo practitioners, that's an oxymoron, but solo practitioners sign up there, and they call themselves the world's largest law firm now because there are thousands of members. They write each other all day long and ask each other questions about cases, advice on how to handle things. But even in my experience on that site as a Georgia lawyer, when there's a question from a Georgia lawyer about a particular case, it's easy for me to figure out sometimes who they're talking about. And so there are concerns with that, obviously, about confidentiality, about conflicts, who knows who else is on the site. And that's another area that my office, first of all, hasn't gotten any complaints about, but second, hasn't begun to figure out how to deal with it.
Thank you, Paula. That was terrific, too. She mentioned about the Neighborhood Watch. I wanted to follow up a little bit. There's one person at the Office of General Counsel who has a responsibility for responding to those complaints that come in from the Neighborhood Watch. And initially, she takes a look at those to make sure that they constitute a rule violation. And then generally, it's a call to the offending lawyer. So far, last time I checked with her was just a couple of months ago, every single call that she has made has resulted in voluntary compliance.
Absolutely.
And we're really pleased with that. We also redrafted the comments to the model rules to try to make the comments educational, both for lawyers and for the watchdogs. That is, unfortunately, it got combined with a complete revision of the rules and the comments before it goes to the court. So it'll be a while, but I'm hoping it'll be in place before our students are in practice. Now, our next speaker, Diane Karpman, you saw the pit bull ad. Well, the state that prosecuted the pit bull ad is just south of here.
Was never prosecuted for that ad.
They didn't?
At California, that ad is in compliance with California regs.
Oh, okay.
I happen to know this.
Yeah, well, the state just south of here that was so concerned about the pit bull ad.
Oh, no, I'm sorry, I thought you meant the DUI. I'm sorry.
Yeah,
no,
right.
Florida did prosecute.
Yes.
Absolutely.
Anyhow, that state, it sort of lost its punch. That state is itself a pit bull of regulation of advertising. That's a problem for Diane, because what she does is roll out of advertising campaigns, and she's got these particular states. Florida is the stickiest of the sticky state. She has to find a way to comply with that. She doesn't get the what Paula described as a liberal approach all the time. Diane?
Hi, my practice is limited to the representation of lawyers, and during the last, about 10 years, it's really kind of focused on class action lawyers, because class action lawyers are, according to most legislation, prone to getting into trouble with various issues, and I'm sure you're all aware of the Milberg firm that got indicted, and actually at this point, all the lawyers have pled, so that means that lawyers who are literally trolling the internet for lead plaintiffs and lead counsel status, in a sense, are terrified about the ads that they're putting out there. They have an affirmative obligation to find as many potential members of the class as they can, and yet, because all the advertising regulations are so idiosyncratic and Byzantine, it's almost impossible for them to be fully compliant with the regulations in all the states. And as you can see from the prior discussion and dialogue, the states take a vastly, terribly inconsistent viewpoint on these particular issues. So when I have a group of lawyers come to me and say, we want to do a rollout, then it becomes very, very dicey as to how to get that ad approved or how to move it into a different state. And that's because at this point in time, most of the states are taking the position that Paula is, or they're little, you know, advertising rules are chaotic at this time in the United States. But there are 6 states that are absolutely obsessed with bettering the legal profession, and they believe the way they can do that is through horrific regulations on lawyer ads. Those 6 states are Nevada, Texas, Kentucky, Florida, and almost Louisiana, but again, Louisiana put it off till later on in the year, and Mississippi. And the way that they drive so many lawyers in my area crazy is they require, or they actually they don't require, they suggest that you get pre-approval of any ad that you're going to run. We found a way of doing that, but it is, many people will argue, well, that's a prior restraint on speech. I think it is a prior restraint on speech. Nevertheless, because it's not mandatory, and you're only asking for an advisory opinion, they've gotten away with this. Florida's gotten away with it for quite a while, and the new proposed Louisiana regs are going to replicate Florida's regs. But it's difficult. The way that we actually have obtained compliance or achieved this, and I'll tell you quite frankly what we've done is we've looked at who's been on those committees, and after they move off the committee, we hired them to walk our ad through. And it might sound like this is an expensive process, very inexpensive. It's a couple hours. Most of the lawyers in this area belong to an organization called APRIL, or the Association of Professional Responsibility Lawyers. And I'm a former chair of that group, and in fact, Micah did a program for us with Mike Downey a little earlier in the year that he was discussing with you. And what we find we do is we just hire a lawyer in that region that's well-known, and we have his cover letter on our ad. And I can't remember any ad that didn't go through on the first review. Although I've heard that some of the bigger law firms are very distressed with some of the regulations that are being imposed, and yet whenever they take it to the appellate level, they are successful. So this is sort of a very unclear area of the law at this point. And that's why we're calling it the sticky states. Let me see what else. And so mostly the regulation will come up in 7.7b, which provides a lawyer, and they will label this as an opportunity to have it pre-approved. And we take advantage of that. According to the ABA, Will Hornsby, who's probably the advertising genius or guru of the world, he says again that national and international firms are very frustrated with this process. I don't think it's a big problem. We figured out how to do it. And that's for the class actions. On the way here, I happened to watch a little TV, and I saw the ad for Cantrex, and an ad, I saw an ad with Aaron Brockovich soliciting people with mesothelioma to join various class actions. None of the TV ads that I have viewed in recent times comply with any state whatsoever. Okay, I mean, don't you watch the ads? Yeah. You know the ad. I mean, I watch the ads on television, and I'm struck with how these ads don't comply. And I'm thinking that I guess if it was a Georgia lawyer, they would call up the neighborhood watch, but until someone reports them, they're non-compliant. And another interesting thing to me, at least, about all these ad complaints, when an ad complaint does occur at the state bar, it is always another lawyer. Clients rarely ever complain. Do you find that
That's
true?
right.
It's always, we don't want them soliciting business in our backyards. It's a NIMBYism thing that goes on. And so the complaints are always about from another lawyer who feels that someone's poaching their business. Also in terms of it's not just sticky states, but the states have wildly inconsistent retention requirements. In California, our Business and Professions Code has a 2-year retention requirement, whereas our Rule of Professional Conduct has a 1-year retention requirement. So, I mean, internally in one state, it's inconsistent. Another very inconsistent aspect of the ad requirements has to do with testimonials. And can you have a client testimonial, or does it create an unrealistic expectation? For example, an Indiana law firm purchased the naming rights on the stadium for $500,000. Now you know that the name that appears on the stadium doesn't comply and list what jurisdictions each lawyer is admitted in. I mean, you just know that it's non-compliant, but yet no one has complained, so nothing's being done about it. And I think that many of these rules are just totally being ignored by members of the profession because they consider them, quite frankly, silly. Another real interesting regulation that pops up in many states is there are various restrictions on the use of images. So, for example, the pit bull image was a big case. I had a case in California where a lawyer was soliciting breast implant participants for potential class action. And he had a very tasteful drawing of a breast. And some other lawyer complained against him. He had to change the ad because it was a symbol. Another symbol or image that is restricted is the use of a dollar sign. That's pretty widely restricted. There's a really great California regulation that requires you in 12-point type to state on the outside of targeted direct mail or an envelope that this is an advertisement, okay? So I had a client, this is many years ago, who was leaving the country, and he had an ad going out to about 2,000 people. And as he left and walked out the door, he told his staff, please put advertisement on the outside of the envelope. Well, his staff they were really going to be ahead of the curve. So they put on the outside of the envelope, Joe is a great lawyer. This violated the rule because it was supposed to just say advertisement. And so he was investigated for about 1.5 years for that. Things have changed, but that was, that puts being under investigation by the regulators puts you under tremendous stress. So, that's just one real Let me see what else I got, because I'm supposed to be doing other. Oh, in terms of choice of law and on an internet advertisement, this gets very intense. We always recommend that you follow the law of your home state. Obviously, that's the person that can actually come after you and discipline you. But then also, we suggest that you follow the law of the home states of any partners in your firm or other lawyers. Just as if you had a piece of paper and it was an advertisement, you'd have to have an asterisk for lawyers who are not admitted in California or not admitted in New York. So too, your advertisement should follow that sort of process. This becomes a real problem when you have an international or multinational firm in terms of where you explain that you're admitted or not admitted. And the reason that you have to do this is because it creates an expectation in the mind of the client that you're admitted in that particular area. You can't comply with all the rules for the different states because that in itself creates a negative expectation. For example, right now, New York has a requirement that on the first page of the web page, it says this is a lawyer advertisement and complies with the New York disciplinary regulation. Well, if you don't practice in New York and you have that ad on your ad, then clearly you're in violation and you've created an expectation in the mind of a New Yorker that you can practice in New York. So it's like it's a very much of a double-edged sword in terms of doing these things. Oh, by the way, the Federal Trade Commission is very active in this area and very opposed to increasing regulations like these 6 states that I mentioned. So there have been a lot of rumblings, lots of investigations, and they're very interested in state regulatory activity. They seem to be sending a clear message that it's possible for states to go too far on the AVO regulation or the super lawyers. They sent the letter that caused the states to back off on that particular issue. And let's see what else I got. I want to talk to you. I hope this was not part of my program, but since the gentleman raised an issue out there, there's something that's going on that I think will soon come to your jurisdiction. It's going on in California right now because we have a lot of foreclosures. And what's going on is loan modification services. Our brokers are attempting to sell these clients to lawyers. The people whose homes are being foreclosed upon need an attorney to help them modify the loan. So what's going on is these non-lawyer brokers will go to the lawyers, they attempt to sell the modification services, and then also charge the client for the services. So it's brokers who put these people in these dire straits and in these junky mortgages are getting a second bite of the apple. My office in LA is getting 2 calls a day from lawyers who want to try this new business model. Obviously, you can't be paying someone to bring you a client, and I think that it raises an inherent and obvious conflict of interest. There was a case out of Ohio last month in which the Ohio Supreme Court disciplined 2 lawyers who are Ohio admitted, and it found the other lawyer who was not Ohio admitted to have engaged in unauthorized practice of law, even though not admitted to Ohio, because he was involved in these high-volume mortgage type scams. So it's something I think you might want to be looking at. We were talking about YouTube. I think YouTube is a vast area for expansion in lawyer advertising because it's free and you cut out the middleman. And I've been urging my clients to start using it. They're a little reluctant. I do have one client that has 5 spoofs of his ads on YouTube. And if you think about the overarching theme of lawyer advertising and that it must be true, accurate, and not confusing, well, all spoofs are inherently confusing until you get it and say, oh yes, right, I understand that. And there's like nothing my client can do to get the spoofs to be removed. And yet it's a tremendous honor to have ads that are so prolific and powerful that people are creating jokes off of your ad. It's like being featured on Saturday Night Live, you know. So, I think that's the end of my, oh, I do want to raise one thing, too, and that was something that Micah raised, and that was, there is a regulator, Mike Dubois from Connecticut, and he maintains, and this is true, that the Connecticut Grievance Committee does not review all web pages, but he did say, this is Connecticut, that that all lawyers, the Connecticut practice book requires that lawyers to comply with their regulations, and a lawyer in Connecticut must submit the name, their domain names, and copies of their advertisements to this particular grievance committee, and it has to be updated quarterly. He went on to state that he considers this requirement to apply even to out-of-state lawyers who market their services in-state on the internet. If an out-of-state lawyer is trolling on the internet for clients in Connecticut, I consider that to give me disciplinary jurisdiction for any violation of the Connecticut advertising rules that I see. So although we only had 6 states that are currently aggressively going after lawyers, we might anticipate that Connecticut might get into that mix very soon.
All right, thank you. What a terrific panel. Now it's time for questions. Questions? Yes, sir.
When I went to Hofstra in 1973, which was 4 years, of course, before Bates and O'Steen, I was invited as the new dean to speak to the Nassau County Bar Association. I talked to them about what I called the professional responsibility to chase ambulances. And I explained why it was important public policy for lawyers to advertise and to solicit, and why there was a First Amendment right that I thought would be recognized sometime in the future.
I remember the article.
Well, in the question period afterwards, one of the lawyers stood up and he said, "Listen, Dean, when I got out of law school, I had to sit on my ass in my office and wait for clients to come in the door. Now you're sending out all of these students who are going to be competing with us for legal business, and you want them to be able to advertise. I say, let them sit on their asses in their offices the way I had to." There was an uproar of applause.
Yep.
That's what we're talking about.
Monroe, I agree with you 100%. The subtext of the Bates case from 30 years ago was people do not know how to find lawyers. And I think that was the by far the most important part of the entire analysis.
But no, the most important point here today is that we have serious professional problems nationwide of incompetent lawyers representing indigent criminal defendants, of prosecutors who routinely abuse the powers of government by depriving criminal defendants of their constitutional rights, by not giving Brady information, by suppressing information, by knowingly putting on lying cops and incompetent and lying expert witnesses. And we are spending all of this time on anti-competitive rules that have little to do with lawyers' ethics.
I'm in favor of no regulations on ads, in case you didn't realize that. I think that people need to find lawyers, and I think that these are anti-competitive regulations that are just there to make people crazy.
My comment was not directed at you.
No, I realize that.
And funny, you should be in Georgia talking about an underfunded indigent defense system. But I do think that there needs to be some regulation of lawyer advertising. But in my mind, if you can, we don't sort of go willy-nilly traipsing around people's escrow accounts assuming that they're going to violate the rules, and I don't see that there's any reason to believe that advertising is any different. We have rules, you know what they are, comply with them. If somebody's injured, they'll file a grievance and we'll take a look at it. But typically the injury isn't because of the advertisement or the way that the lawyer has gotten to the client. Typically the injury is because the lawyer's incompetent.
What's the comparative time that your office puts into lawyer advertising as compared with the time that your office puts in to incompetent representation of indigent criminal defendants and unlawful conduct by prosecutors?
It is funny you should ask. We estimate that probably 1/3 of the grievances that we get right now in Georgia are from prisoners alleging a lack of communication or some sort of problem with the representation. And I don't know how familiar you are with Georgia's indigent defense system, but it is in a state of crisis. It's completely underfunded. Lawyers have caseloads, 300 cases. There are lots of young lawyers who are being made to do things that they haven't been properly trained for. But on the other hand, we spend way more time on that than we do on advertising. We've got one lawyer who spends probably about 1/5 of her time with this lawyer advertising task force, and we don't, frankly, as I told you, I think, pay as much attention maybe as the members of the bar would like for us to.
How many lawyers have been disciplined for incompetent representation of indigent criminal defendants?
I don't know. I haven't broken it out that way, but Unfortunately, if we get a grievance that alleges a lack of communication and send it to the lawyer for a response, quite often we don't get a response. And, you make it pretty easy for us. But we have taken a policy in my office now with the permission of our disciplinary board to try to work those cases out instead of prosecuting them, because we understand that we're dealing with lawyers who are completely overwhelmed with the volume of what they have to deal with.
That's not an excuse.
I know.
They have, when they take the overload, they are taking on a conflict of interest.
But what do you say to a young lawyer who would have to stand up to a judge and say, I refuse the appointment that you have just made because I
say to that
go to
young
jail?
lawyer, you say to the judge, Your Honor, I cannot accept that appointment because I cannot give effective assistance of counsel consistent with the Constitution, and I cannot give competent representation consistent with the ethical rules if I take on that representation. And if the judge nevertheless insists that the lawyer take the case, the lawyer has an obligation under the ethical rules in most jurisdictions.
Not ours, but go ahead.
To report the judge for the judge's unethical conduct in making the appointment under those circumstances. The lawyer then has an obligation, when the plea bargain is offered, to tell the defendant, I cannot advise you ethically whether to take it or not. This is the offer. I have to communicate it to you. I cannot tell you whether to take it or not because I am forbidden ethically to do so until I have investigated the case, and I haven't been able to do that. And then if the defendant decides to accept the plea, instead of standing up next to the defendant as if the defendant is being represented and providing a facade of representation, covering up the violation of Gideon, of the Sixth Amendment, the lawyer should say to put on the record, Your Honor, this defendant is pleading without the advice of counsel because I have not been able to put in the time to investigate the case, and I have not been able to advise the client about the plea.
I absolutely respect what
Monroe,
you're saying,
okay,
but I don't know that that's, it's easy for me to sit up and advise a new lawyer to do that. I'm not the one who's standing there in front of the judge.
Well, maybe we should do this with,
I apologize.
with Professor
It's
Friedman's
obviously something.
very good point noted, that there are things that are a hell of a lot more important for an Office of General Counsel to do than prosecute advertising cases. I think we'll all agree with that. Are there, nevertheless, questions about the advertising? Yes, sir.
I started advertising 2 months after the Bates decision was decided. And started out in the newspaper, do we need a lawyer? I remember the first client who came to see me had worked at a department store as a janitor, and he left and he didn't get a severance pay. It took me about 2 months and I got him that pay. The last thing that I remember doing is I had a billboard, and it was above the parking lot that they kept repossessed cars. And we put it in the billboard, has Ford repossessed your car lately. Got quite a few clients, and one day we had a case in federal court, and it was the woman had been molested by the repossessor. We sued out under the Fair Debt Collection Practices Act. And
Interesting, huh?
We were there for a settlement conference, and they were at like $70,000, and I wanted $175,000, and we settled it for $150,000. On the way out, the attorneys from Ford Motors said, we were just wondering, what kind of attorney is going to put up that kind of an ad for clients? And I looked them straight in the face, and I said, the kind that pays you, that your company will pay $170,000. It is so important that people know that there are lawyers out there that have specialties or areas that they can help them. And I think what we need to look at is not the anti-competitiveness issue. And when that comes up, we say, we're sorry, it's not part of our rules. And instead, make sure that advertising informs and helps individuals find lawyers for the needs they have.
Tell that to Texas, Nevada, Kentucky, Florida.
Well, I wanted to, the question that you asked before, you know, the question of unauthorized practice of law and how you deal with these non-lawyer entities is that, you know, the places where you have been, where people have been successful in dealing with them is when you can catch them dispensing legal advice. And that's kind of what you would need to end up with, is a situation in which you meet with a client, they say they went to them previously. If you can basically sit there and prove, or have somebody prove that they've dispensed legal advice, then you can send the proper authorities over after them. The other related issue that a lot of people struggle with is, again, our attorneys, like the Ohio example that Diane gave, are the attorneys that are airing commercials nationally for Yamaha, whatever that ATV is, you know, and you get angry about it in Georgia or where I live in Pennsylvania, and you know, you actually need to rely on the state in which they are a member of the bar to basically go after them and discipline them. We don't have that kind of reciprocity in this business, but that's really what you often need to do, is go to the bar of the home state that the person practices in. But you know, I'd say in my practice, most of my law firms in which I'm advising them in ethics, they're usually ML 200 firms. I can tell you that 9 times out of 10, the state that they get in trouble with is not the state that they're based in. It's always one of the satellites. But basically, it is difficult, and those are the areas that you don't want to go chasing after people using your bar resources because you didn't put the sentence on your ad. But you do want to go after the people that are either non-lawyers practicing law in your market, or lawyers from other markets trying to practice law, unauthorized practice of law where you live.
Let me just throw out one thing too for anybody who is interested in the topic. The American Bar Association's Law Practice Management section has a very good set of best practices that I bet some of these folks actually helped develop for lawyers with their internet advertisements or websites or whatever. And they talk about things that ought to be obvious, but that you don't see on a lot of websites, like putting a date for the material that's there. You know, when was this material added? So that if somehow the site gets abandoned later and somebody's going to it 2 years later and the law has changed, they aren't relying on old information in the self-help portion of your website. But it's just a little laundry list of 10 or 12 things to consider as you are setting up your internet ad. And they are the things that I would be concerned about if I were looking at an ad for potential misleading or claims that it was misleading.
I want to say one last thing. We're beginning to see, I'm very active in legal malpractice, we're beginning to see malpractice claims based upon statements made in internet websites, and this is sort of going to be a wave of the future. It's only at this point sort of another ornament on an overly decorated Christmas tree. But I think that more and more frequently we need to be aware of that. And it's not so much the bar regulatory activity that you need to be afraid of, but the civil liability that could be engendered.
Thank you so much. We are out of time. There's so much more that we could explore here. Does prior restraint really not apply to commercial speech? Is the court serious? It's just dicta. Micah mentioned about the difference between informational websites and commercial websites, and he felt that there are none, are no differences, that we could pursue that at length. And that I wonder about the difference between passive and active internet, whether there should be different rules to apply depending upon how passive the internet site is. But we'll have to pursue those at another time. Join me in thanking the panel. I've gotten word from the boss here that we should be back in 10 minutes.